Jefferson County Court at Law number 2 is now in session. The court is in session with the arraignment docket scheduled on today's date of March 7 of 2023. Good morning. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to County Court at Law number 2 today because you have a misdemeanor case in this court. Criminal cases are divided into felonies and misdemeanors. Your misdemeanor cases are commonly referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, your felony cases, as I mentioned earlier, are normally referred to as your most serious type of criminal cases. If you had a felony case, your felony could either be a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If you were convicted of a state jail felony, the range of punishment, minimum 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum of 5 years to a maximum of 99 years to life in the state penitentiary and a fine up to $10,000. Or if you're convicted of a capital murder, the range of punishment is either life or death by lethal injection. Now, you do not have to worry about that because, as I mentioned earlier, the criminal case that you have in this court is a misdemeanor case. Your misdemeanors are divided into 3 categories. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, normally the Class C misdemeanors are handled in the JP court or the Justice Court or the city court, which is commonly referred to as the municipal court. If you have a Class C misdemeanor, that means your case was appealed from either the JP court or the misdemeanor court, and that's how it got to this court. Now, the range of punishment for a Class C misdemeanor is fine only. That simply means that you cannot be given jail time for the conviction for this offense. However, if you fail to pay your fine and court costs, the court can issue what is called a capious pro fine, which means that you can be arrested and be required to sit out the fine if you do not pay the fine. Now, if you're convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you are convicted of a Class A misdemeanor, the range of punishment is 0 days to a maximum of 365 days in the county jail, which is a year, or you could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. The arraignment is an opportunity for the court to tell you what your rights are, what your options are regarding the case that you have in this court. Now, first of all, the document that you have been handed out or handed to you, the first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. First of all, you have a right to have an attorney. And in that document, it states, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. If you want an attorney and do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. Now, the financial questionnaire is titled Jefferson County Affidavit of Indigence. And once you fill out that financial questionnaire, the reason why you have to fill out the financial questionnaire is so that the proper person can determine whether or not you qualify to have an attorney appointed to represent you. Now, if you want to represent yourself, that is, you want to waive your right, meaning you want to give up your right to have an attorney and you desire to represent yourself, then you cannot speak to the prosecutors. Now, right before you are two prosecutors that work for the district attorney's office. They are assistant district attorneys in Jefferson County, Texas. You cannot speak to them if you want to represent yourself unless you first sign a written waiver of your right to have an attorney or to be represented by an attorney. As I mentioned earlier, a waiver means that you're giving up your right. So you're waiving your right to have an attorney or you're giving up your right to have an attorney. Once you sign that waiver, then you'll be able to speak to one of the prosecutors about your case. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, you may change your mind at any time and request counsel or request an attorney be appointed by the court. At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney or give up my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that's titled defendant. And you will place today's date on the line that's titled date. And today's date is March 7th of 2023. Now, if you are desiring to waive your right to have an attorney and to represent yourself, then you have to read and sign the next document, that is the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 7th day of March of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, March 7th of 2023. Now, also, as a defendant in a criminal case, you have a right to have a trial by jury. But those young people are sitting in that area over there, we call that the jury box. 6 citizens will be selected to sit on your case, to listen to the evidence in your case, decide whether or not you're guilty or not guilty after listening to all the evidence. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, your case will come before the court or before the judge in one of 3 ways. One way it will come before the judge is by way of a bench trial. A bench trial is a trial by judge only. And the judge will listen to the evidence, and after listening to all of the evidence, the judge will decide whether or not you're guilty or not guilty. Now, if you desire to waive your right to have a trial by jury or a trial by judge, and you would like to enter a plea, then you could enter a plea. What a plea is means that you're pleading either guilty or no contest to your charge. For example, if you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or if you enter a plea of no contest, you're telling the court that you will not be fighting, or you will not be contesting those charges. So if you enter a plea of guilty or no contest, your case will come before the court by way of an agreed plea bargain if you and the district attorney have reached an agreement to settle your case. We call that an agreed plea bargain. Now, your case will come before the court. The court will decide to follow, which means to accept or go along with the plea bargain. And if the court does go along with the plea bargain, then you will be able to, if you decide to appeal your case within 30 days, you have to get permission from the court. Now, if the judge does not go along with the plea bargain agreement, then you'll be entitled to withdraw your plea. That simply means, for example, let's say you and the state has reached a plea bargain agreement of, say, 2 days in jail, and it comes before the court, and the court says, well, I'm not going to follow the plea bargain agreement. Then you could tell the judge, well, judge, I withdraw, or I take back my plea of guilty or no contest. If the judge doesn't go along with the plea bargain agreement, you are entitled to withdraw your plea. Now, as I mentioned earlier, if the judge does go along with the plea bargain, and if you decide within 30 days that you would like to appeal your case, and what an appeal is, you think that you've been wrongfully convicted, or the court committed an error by convicting you, and you would like a higher court than this court to review your case. That higher court is the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case, and they will decide whether or not to grant your appeal or deny your appeal. If they grant your appeal, they can simply find you not guilty, and the case is over. Or if they deny your appeal, then you can appeal it to a higher court than them. That higher court that you can appeal it to is the highest court in the state of Texas, the highest criminal court in the state of Texas. It's called the Texas Court of Criminal Appeals. They're located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. What that pro se means that you'll be representing yourself. You will not have an attorney representing you, and you would have to file a petition, pro se petition, to the Texas Court of Criminal Appeals, asking them to review your case to see, 1, whether or not your appeal should have been granted, 2, whether or not you've been wrongfully convicted, or 3, whether or not you have been convicted by this court in error. And so once they review the case, they could either deny or grant your petition. If they grant your petition, they can simply find you not guilty, or they can order this court, send the case back down to this court and order this court to give you a whole new trial. If they deny your petition, then at that point, your conviction will stand. Now, you also have a right to have, you can have what is called an unagreed plea bargain. And what an unagreed plea bargain is, it means that you and the state have not been able to reach an agreement to settle your case. Therefore, you want your case to come before the judge or the court, and so that the court can assess punishment. That's an unagreed plea bargain. So if you waive your right to have a jury trial, well, first of all, you have a right to have a jury trial. If you waive your right to have a jury trial, your case can come before the judge by way of a bench trial. And if you waive your right to have a bench trial and a jury trial, then your case will come before the judge by way of an agreed plea bargain or an unagreed plea bargain. You also have a right to have witnesses to come to court. Witnesses sit in that chair right there to my left. We call that the witness stand. They will testify. They could either testify for you or against you. If you represent yourself, or if you have an attorney represent you, you or your attorney can ask them questions. And we call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. That simply means that you will not be calling witnesses. It does not mean that the state or the district attorney's office would not be calling witnesses. Now, you also have a right not to testify yourself. We call that the Fifth Amendment right against self-incrimination. That simply means you have a right not to testify against yourself in your case, and the state of Texas or the government cannot force you to testify in your case. Now, you can waive or give up your Fifth Amendment right against self-incrimination, and by doing so, that simply means that you will be testifying in your case. You also have a right to have discovery, and what that basically means is you have a right to see the evidence that the state has against you. We call that discovery. The state, you can have, the state can give you access to that discovery. And if you have an attorney, your attorney can be given access to that discovery. Now, you're here today and you're out on bond. You're either out on a personal recognizance bond. That simply means that you did not have to pay any money to get out of jail. You release under your own personal recognizance, or you are out of jail on a what is called a surety bond, which means that you had to pay a bondsman a percentage of the bond to get out of jail, or you are out of jail on a cash bond. That means that you have to pay the full amount of the bond to get out of jail. Now, every day that you spent in jail, that jail time can be used as credit in your case. So, for example, if you have, let's say you spent 5 days in jail, and you and the state have reached a plea bargain agreement, and that agreement is that you will serve 5 days in jail. That simply means that you will not have to serve any more time in jail, because the 5 days in jail that you have already served will be given to you as credit toward your time in jail. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that simply means that you would have to serve 2 more days in jail, because you will be given 5 days credit toward the 7th. Now, every day that you spent in jail also can be used as credit towards your fine and court costs. Every day that you spend in jail will be credited as $100 per day that can go towards your fine and court costs. Now, let's use the same example I used earlier. You spent 5 days in jail. You and the state have reached a plea bargain agreement. And this time, the plea bargain agreement is for you to pay a fine and court cost of $500. You will not have to pay the $500 because your 5 days in jail is equivalent to $500. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it. Now, If they are offering fine and court costs of $700, you spend 5 days in jail, that means you have to pay $200 because the $500 have been credited toward the $700 fine and court costs. Now, you'll be required to pay the fine and court costs on the day of the plea. If you cannot pay it on the day of the plea, then the court can put you on a payment plan. That simply means that you could be required to pay off the remaining balance in installments over a period of time. Now, let's say you are unable to pay the remaining balance over a period of time because you do not have income. That's not a problem either, because the court then can convert your fine and court costs to community service. And that simply means you would have to work off the remaining balance in community service at a nonprofit organization in Jefferson County. You will receive $12.50 that will go toward your fine and court costs for every hour of community service that you perform. Jefferson County has a program that is called pretrial diversion. If you have never been in trouble before, with that program, they will dismiss your case and put you in the program. And if you successfully complete the program, then this case can be removed from your record. It can be erased, wiped off, deleted from your criminal record. And in order to qualify for the program, one, you would have to get an attorney. Two, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And three, it has to be your first offense. So you cannot have a criminal history to get into that program. Now, Jefferson County DA's office has another program which is similar to pretrial diversion, and that program is called Veterans Court. It's for veterans only. If you're a veteran of any one of the branches of the United States military, then if you qualify for that program, the same thing would happen. They'll put you in the program, and I think that you can get it expunged from your criminal history. Now, if you're interested in any one of those programs, just let the court know, and the DA's office will be able to direct you into talk to the right person in their office to get the paperwork started so that you can see if you qualify for the Veterans Court program. Now, this court, County Court at Law number 2, has a program that is called a Community Safety Initiative. It's the CSI program. That program was started by me within the first 100 days of taking office. I started that program in March of 2017. And then with that program is designed to address the issue of what we call recidivism. Recidivism means that when people commit crimes over and over, well, this program is designed to address that. And the way we address it is by having partnerships with our local agencies in Jefferson County. And one partnership that we have is with our local Spindletop Center. Spindletop Center is our local mental health center. With Spindletop will be able to do private interviews, develop an assessment, do an assessment, and then they can develop a treatment plan, either outpatient or inpatient treatment for individuals that have mental health issues. Now, your mental health issues, you do not have to be incompetent or insane. You could suffer from either bipolar, schizophrenia, anxiety, depression, post-traumatic stress, a whole host of other mental illnesses. They'll be able to address those illnesses that you may have. Now, in the jury box, the young people that I showed you earlier, they're from Spindletop Center, and they'll be out to talk to you in a few minutes once I finish with the arraignment, and then we'll have, I think either Deputy Hinton or Chris is going to come forward and give you more information about the program that they have to offer at Spindletop. Now, Spindletop also has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery, and the Alcohol and Drug Abuse Council has a program that is called OZAR. And with OZAR, OZAR is a program that stands for Outreach, Screening, Assessment, and Referrals. And basically, those programs are basically similar in that they will basically do an assessment. First of all, they'll do a screening and assessment, and they'll develop a treatment plan, either outpatient or inpatient, to treat your needs for either alcohol or drug abuse. Now, if you are unemployed and do not have a job, or you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you get trained in one of the areas that you select, then they will assist you at getting a job in the area that you're trained in. Now, if you have not finished high school and you would like to get a GED, graduate equivalency diploma, then they have a program at CICE where they can assist you at getting your GED. Now, all of these programs that I've just mentioned to you will not cost you anything. They are free. Only thing that you have to do is take the time out to participate in these programs so that you can get the ultimate benefit from your participation in these programs. Now, also, these programs, as I mentioned earlier, these programs are designed to address various issues and concerns that you may have. And in County Court at Law number 2, we do not have court as usual. We have unusual court. And the reason why I say that is because we do not just have individuals come before this court. The reason why we have people come before this court, because we're trying to produce productive people. Also, we do not just arrest the problem, we address the problem. And we're trying to make Jefferson County a better place for all of us to live, work, and go to school, raise our families and our children. We also trying to produce productive people, because we believe that if we produce productive people would not commit crimes because they have too much to lose. And so therefore, we have our community safety initiative. And we're trying to make a difference, not only in our community, but we're trying to make a difference in the lives of the individuals that comes before this court. Now, if you're interested in that, in our program, just please let us know, and we'll be able to assist you at getting into one of the programs that you may be interested in. And the other thing is, all of these programs that I have just mentioned, all of these programs can be used as community service. So for example, let's say you were ordered to pay a fine in court costs, and you could not pay your fine in court costs, and so we converted your fine and court costs to community service. And so if you're in the Spindletop program, every hour that you do in that program, $12.50 will go toward your fine and court costs, and 1 hour will go toward your community service. If you're in the job training program, every hour that you spend in class training, 1 hour will go toward your community service, $12.50 will go toward your fine. Or if you're getting your GED, the same thing. 1 hour of participating in your GED program will go toward your community service, and $12.50 will go toward your fine and court costs. So I like to say that you're killing 3 birds with 1 stone. You're in the program, you're getting community service, and you're paying your fine and court costs, all by doing one thing. So if you're interested in these programs, just please feel free to let us know, and we'll be happy to point you in the right direction so that you can get the assistance that you need to get into the program. So at this time, we'll either have we'll have Chris that's going to come forward from the Spindletop Center, and she's going to tell you, she's going to give you some information about the Spindletop Center. Okay, we're going to have Chris and Deputy Hinton.
He adds a lot of that. So, I know he's a school officer, we actually work with him as well, we work with a lot of different resources here. But he mentioned that, that's not going to be used also resource, there's a lot of things here in our towns or long time area in general that are well funded, they're just not well active. And if you're dealing with a lot of other things in your life at this moment, then maybe doing set up capacity is something you can really work in, because we're trying to get help with that because of the load. And it's a mental health, and I'm going to mention quite people in the on that. Usually it's anxiety, it's depression, it's life stress that happens that come up. The whole process is not just getting you. There's almost always something here that you're dealing with harm. You just didn't know the good talk to somebody about whether it's financial abuse. Everything that we do is pretty, every resource because there's outside of us, if there's public job, then we help with housing assistance, with financial assistance. We have other resources in the area too that do offer DDBs, they offer certifications, things like that. They're all either sliding fee scale or they're free. There's medical resources, there's
So we're gonna need one thing from you to share that need with us, a document that Chris gave you when you first come in. If you'll fill that out completely, tell us how you want to be contacted, either by phone or text. If you side text, if you'll just let us know that you received that text, and we will be in contact with you. We'll work with you for your particular situation. If any of this applies to you, maybe it doesn't apply to you, maybe it applies to a family member. We'd be glad to work through you to get to that family member and help them get them the resources they need and would best fit their particular situation.
now that form that does function as a baseline for the consent, everything on it is protected under state law. It won't be shared about it. The only thing allows you to do is transparently look for resources in the area and contact you once, but your phone number doesn't go anywhere else, your address doesn't go anywhere else. Again, it only allows me or one of our interns like Tracy over there to contact you once. You have to continue contacting us for us to be able to, or let us know that you want to be contacted. For us to be able to do that. We'll work as hard for you to do for yourself, because you know you want to. So
We also have a flyer we want to give you before we leave here today. That flyer tells you a little bit about the court program, but also some of the advantages of the program itself. But also there's a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help.
the important thing about number 2 is that it is almost statewide. We recognize a lot of people come to court in Jefferson County and not from Jefferson County. We don't have any type of catchment area, so it doesn't matter if you don't live here, we can still try and find something to help. But that 1-800 number is like 90% effective. If you find yourself up and down the side of the road, you can hold anybody else, it's still a good number to have. You keep that handy. We also do have the option to speak today privately if there's something that you know you need. You can go, or if there's any anxiety, medical issues, anything you're dealing with outside the courtroom, we can step back there and do a baseline assessment and take a report and try to if you want to, or just take a moment to talk and breathe. But it's up to you, we do have that option.
Just shortly, when the court goes into recess, we'll pick up those forms from you. We'll get those flyers to you as well. Any questions you have, we'll be able to answer. Thank you. Thank you, Your Honor.
Okay, you're welcome. Okay, gentlemen, the court is going to allow you to finish filling out the paperwork if you haven't finished. Now, if you need some assistance in filling out the paperwork, we have our court personnel who will be happy to assist you in filling out the paperwork. Now, the court is going to go into recess, as I mentioned earlier, to give you time to finish it. If you finish filling out the paperwork, then we'll come by and pick it up. And then what we're going to do after that is call you up one at a time. Now, if you need to use the restroom, there's a restroom. If you go out the door, it's right here to the right of this courtroom. And it's at the end of the hall in front of County Court at Law number 3. Okay? So at this time, this court will be in recess.